Welcome, everyone. Thank you for joining us for the webinar on New Proposals and Emerging Practices, a discussion between Europe and Asia on EHRDD. I'm Monica Shrestha from QDesign, also accompanied by my colleague Aziz Kurung. We will be your technical facilitators today. Everyone. The chat and the Q&A function are disabled for this session. Sorry, the chat and the Q&A function are enabled for this session. So if you have any questions, please feel free to write it on the Q&A box. For the audience on YouTube, please feel free to use chat box to ask any questions or send comments. Please note that the session today is recorded and live streamed. If you have any questions about Zoom or require technical assistance, please feel free to raise your hand or drop a message into the chat box. I will now hand over to Jehan, Aziz, Abdul. Jehan, the floor is yours. Thank you.
Thank you so much, Monica. Good morning, good afternoon, and good evening to all of you joining us today, and a very warm welcome to today's session on New Proposals and Emerging Practices, Environmental and Human Rights Due Diligence in Europe and Asia. My name is Jehan, Business and Human Rights Specialist at UNDP Malaysia, and I will be moderating this session today. I would like to first thank you for spending the next 1.5 hours with us as we hear from our esteemed speakers and experts on their thoughts on the newly proposed EU Directive on Corporate Sustainability Due Diligence that was recently launched on the 23rd of February 2022. Existing due diligence challenges includes the lack of legal clarity on due diligence obligations, complexity and reach of global value chains, internal and external market pressures, information deficiencies, and cost. The proposal aims to foster sustainable and responsible corporate behavior throughout global value chains by addressing negative human rights and environmental impacts to achieve climate neutral and green economy ambitions. The directive also aims to build resilience to sudden changes in global value chains. We will hear more later on some of the key details of the proposal by the EU Commission, and following this, an analysis of some of these impacts from the Asian perspective. Before I run through the agenda, I would like to first share the objectives of today's event. With about 640 registrations and potentially more of you joining our live stream on YouTube, mainly from Asia and Europe, and of course all other regions, with high participation of businesses and civil society, we hope all of you leave today's session with a better understanding of the UN Guiding Principles on Business and Human Rights, which is the world's most authoritative normative framework guiding global efforts to address and remedy the adverse impacts of business operations on human rights and the environment. We also aim to clarify the broad outlines of the proposed EU Directive on Human Rights and Environmental Due Diligence, and how it will shape emerging HRDD practice in Asia. Our speakers today will explore developments in Asia on human rights due diligence, what has been done, and what is currently being planned across the region and in countries. Finally, we would like to advocate for a wider adoption of HRDD practice among the business community in Asia and other regions through sharing of lessons learned. Essentially, today we will discuss on what you can do to create an improved human and environmental rights ecosystem. We will begin today's sharing with welcoming remarks by UNDP, followed by opening remarks as well as an overview of the proposed directive on corporate sustainability due diligence. We will then hear more on the implications of environmental and human rights due diligence for Asian businesses. Moving on to reflections, we will hear from our esteemed speakers on their thoughts and analyses on how the directive will impact countries in the region. Thereafter, we will open up the floor for questions from the audience before closing the session. Before we proceed any further, as always, I have a few housekeeping announcements for both speakers and participants. Given that this event is rather compact in nature, I do hope that all speakers do try to keep within the allotted time. Comments and questions are very much welcome throughout the session. You may add your questions to the Q&A box at the bottom of your screen, and also share comments in the chat box to your right. For questions, as far as possible, do direct them to the specific speakers you have heard from today. We also implore you to share your thoughts on Twitter and LinkedIn using the hashtag EHRDD and hashtag BizHumanRights. You can see these in the chat box to your right. And now we will kick off the dialogue with a few words from my colleague, Niloy Banerjee, Resident Representative, UNDP Malaysia, Singapore, and Brunei Darussalam. Over to you, Niloy.
Thank you, Jehan. Can you hear me? Give me a thumbs up if you can. All right, lovely. Kun Ruenvadee Suwanmongkol, Alexandra Kuxova, distinguished panelists, Prof. Aishah, my colleagues, Livio and others, good to see you all. Good afternoon, good morning, good evening, wherever you are. And to all our audience online, very nice to have such, I see about 241. That's an excellent number. I hope it'll climb as we go along. I'll just say a word of thanks to the EU, our partner in this. We work closely in the region. Yeah, as you heard, Jehan's marching orders, which has to be really short and don't go over time. She's reminded me many times, but a quick incidents that has happened in the last few days, colleagues, which as you know, the UN General Assembly passed a resolution to actually to start the convention to ban plastics in a couple of years' time. And what that did was the whole sort of plastics industry in Malaysia. Malaysia, where I serve, is actually quite per capita consumption and wastage of plastics is quite heavy. The whole plastics community here suddenly went, oh my God, where is this coming from? And we have to gear up and do something. And so our phone in the office has been ringing off the hook because none of us were prepared. Certainly the industry wasn't, and the consumer sector is not. So why am I telling this story? Because really we have to anticipate what is coming down the pike and what is good business, what are our consumers wanting, and where should we change our behavior. And that's really, this is the anticipation that will make for good business versus business gone bust in the days to come. So let me maybe just touch upon a few quick points and leave it to the experts that will follow. First, it's not an afterthought to have both social and environmental standards thoroughly built into our business practices. Particularly in Malaysia, we are seeing a big upheaval in our commodities sector, our rubber and rubber gloves and palm oil sectors, where we are seeing quite a bit of sanctioning by international companies. But also on the other hand, we are seeing some good movement in Malaysia. Malaysia has now joined the Human Rights Council. It's a member this year, and we've also just ratified the ILO Protocol 29 on forced labor. Our team, Jehan and colleagues, are also working with Professor Aishah on the National Action Plan. But it's not, we haven't been able to make it a national, get it into the national consciousness. It's not everybody's business yet. And we have to. It's not a compliance issue. It's not because the EU is saying it or UNDP is saying it or anybody. It's actually genuinely good business. In this day and age, we cannot have poor work conditions for labor. We cannot be doing practices which are not environmentally friendly. There's just too much information, too much awareness, and we'll be called out. And consumers and shareholders will punish us at what due to our business practices. So that's it's as simple as that. And so my first point is really, let's not stick to the old excuses that transforming businesses will cost a lot, etc., etc. It's really good business sense in the long run. My second point is an appeal really to the leadership. This change has to come from the boardroom. This change has to come from C-suite and right up there. It's not going to happen on the factory floor level. So I really encourage and implore the leadership in these sectors to come up and change business practices. My third is actually a little bit of appeal again, but it's really that this directive covers SMEs, because in our region, SMEs are the biggest employer in the private sector. So it's very, very important that small and medium enterprises are brought within the ambit of this, and otherwise we will leave out a very large portion of our workforce from the protection and this progressive thinking that's coming into play. So I'll probably just close by a couple of thoughts on what we in UNDP can support you with. You'll hear more from colleagues as we go along today. But just to say that not only are we working on the National Action Plan here and undertaking various consultations around that, we want to go to the next step. Our neighbor to the north, Thailand, is already implementing this. We are also doing a lot of trainings, colleagues. So please, if there is interest, we would be happy to help you out, your companies, with training and sensitization and awareness sessions. Most of all, we are providing a space for dialogue. That's what the UN is. It's a platform for dialogue. So, and as many stakeholders as possible, as diverse a range of stakeholders as possible. Finally, we are also now keen that we try and do what you would call an ecosystem mapping, which is, generally take a survey like our neighbor Indonesia has done, to see how companies are actually doing on a league table of social and environmental protection. But all of this can only happen if we have a vibrant community around us. So this is really an appeal that our doors are open. Jehan's contact info is all over the place. You can please get in touch. Livio and Sean in Thailand, always available. So happy to talk. We always happy to engage in dialogue, and we can do this together. So with that, I'd like to wish you all a wonderful session. I'll be listening in off camera and happy to answer any questions afterwards. But otherwise, all good. Have a lovely day.
Thank you, Niloy. I'm very impressed. You managed to keep that within 5 minutes. So I particularly enjoyed your message that it really is up to us in Asia to make business work for us all. That our doors, UNDP doors, are open for collaboration, and hopefully by directors and decision makers on due diligence education. I would like to now call upon Alexandra Kuxova, Policy Officer at the Directorate-General for Internal Market, Industry, Entrepreneurship and SMEs of the European Union Commission, to provide some opening remarks and a much awaited overview of the proposed directive and its implications on Asian markets and trade relations. Over to you, Alexandra.
Hello, good morning, good afternoon, good evening to everybody. I'm very pleased to be with you today, despite some technical issues beforehand, and guide you through the new proposal on the directive for corporate due diligence. As you know, Commission has various commitments, be it internationally, has its own priorities. Could you please just put the next slide? So we are very dedicated to deliver on the Sustainable Development Goals, on Paris Agreement, but we have also translated it in our Commission priorities within the Green Deal and Just Transition. The due diligence and sustainable global value chains were part of the various policies, as you can see, a lot of strategies. One of them also trade policy review, which is very important, where we want to have more sustainable and fair trade. So as you see, this was an important element for many policies. We had also very strong call from European Parliament, from the European Council, so member states, to act on this. And also there was a huge support from stakeholders. We received almost 500,000 replies in the open public consultation. There was a huge support, of course, from NGOs. Around 96% were vocal to support such a proposal, but also business community was actually there with us. And there was a lot of support, around 60 to 70%, to act on due diligence, a little bit less on the director's duties. So what was mentioned before, that the CEOs and should be the ones responsible, there was a little bit less support from businesses. Next slide, please. What is so until now, the company's been using voluntary frameworks to do the due diligence, be it under OECD guidelines, the UN guiding principles, and ILO recommendations on decent work. We know that more or less 1/3 of companies has put in place some kind of due diligence. Of course, mostly we speak about the larger ones. There is already some legislation, be it on conflict minerals, or sometimes it's very specific for a sector or very specific for a particular issue like slavery, but there was not a horizontal framework as such, besides two recent laws in Europe. One is the French law, and the other one is last year adopted the German law on global supply chains. Next slide, please. So just maybe to explain, and this will explain a little bit the objectives and also the reflections we had in mind when designing this due diligence proposal. As I said, until now, it was mostly done on a voluntary basis. So we need to translate this into something which could work as a law. So on one hand, we wanted to step up the culture of no harm, and not only in Europe, but really outside of Europe. And we think that through the value chains, this is possible because, the value chains are global and extend to third countries. But we also wanted to make an example, maybe for like-minded countries to follow this standard. As I said, we needed to do this as a law. So we had to provide legal certainty for companies at the same time, while building on what already exists in the voluntary framework or in the existing due diligence laws. So we really try to go through what is already there, be it on due diligence, be it on sustainability reporting. Also, as I said, we really try to build as much as possible on UN guiding principles and OECDs, but sometimes you will see that some of those elements are not fully aligned. And as I said, some member states were already acting on this, and it was very important for us. And we knew that many were reflecting on doing a horizontal due diligence. Some were maybe reflecting working on in a particular sector. So we saw that also our European legislation in the single market was getting really patchy. So this was extremely important for us to provide one set of rules for the companies, because we think that having this, the legal certainty and defragmented single market, avoiding additional cost for businesses, it can give them an additional boost to actually do the due diligence. And as I said, with the consistency and building on what exists, we didn't want to duplicate the rules either. So where we could, for instance, on the sustainability reporting, we really used what is there already in Europe on these matters. We also think that this will provide more transparency, because we see that investors in their daily business now want more and more information and take sustainability in their decisions when they give the investment. And we see, at least in our region, more consumer pressure for more sustainable goods, and they want companies to act sustainably. So this was another element. And of course, this transparency links to accountability of businesses for what they do as well. So also provide access to remedy for victims in something that goes wrong. As you know, voluntary framework is not the same as law. And if you want companies really to make this applicable and feasible for them, we had to also take into account the proportionality. So not to overburden them, have clear rules that they are really able to implement on the ground, and also that we had in mind the SMEs. Even though we don't include them in the proposal, we really wanted to make sure the indirect impact on them is mitigated. And due diligence would not be possible without fostering further collaboration in the industry and building leverage. Next slide, please. You can move on. So now I will explain who, what, and how. So which companies are concerned? We have distinguished two groups of companies based on their risk profile and also the size. On the top of it, we also distinguish between AU companies and non-AU companies. So we cover both. I will explain further. And as already mentioned, we completely excluded small and medium-sized enterprises. So for the group one, basically, these are the large companies which have more than 500 employees and turnover, worldwide turnover more than 150 million when it comes to European companies, and only AU turnover for non-AU companies. So these are the companies which are which have a specific legal form, limited liability companies, and on the top of this we have also regulated financial companies in the scope. The group two is a little bit more special because there we don't cover all the sectors. So there are companies which are a little bit smaller in size, but act in one of the high impact sectors, which we defined, and I will explain in the next slide how we define them. And these companies will have simplified rules and also have a little bit longer time, a phase-in to actually implement the due diligence. So in total, in AU, we cover approximately 13,000 companies. Those are the companies which are actually strong, economically strong to implement the due diligence. That's why we have this double criteria, turnover and employee count. So this is we actually, in our analysis, we found out that those companies generate approximately 52% of all AU turnover. So just to give you an idea, I mean, the situation is the same as what was mentioned in Malaysia. Of course, also in Europe, 99% of companies are SMEs, and 93% of them are actually micros. So for us, it was important not to have them directly in the scope, because anyway, there will be the trickle-down effect. And in terms of non-AU companies, we cover approximately 4,000 companies. So next slide, please. As I said, we have designed this group 2 companies, so the smaller ones, and we have analyzed many available sources, be it US list of forced labor goods. We have looked at the national studies from Germany and the Netherlands. We had looked at commission's work on decent work. So we really try to analyze where the highest impacts would be present, and on the top of this, we used as a criteria also where the OECD guidelines were already available to make this this implementable as soon as possible. So we covered 3. I will group them because we don't have that much time to go into detail, but you have it on the slide. So we cover garment and footwear in the group 2. Agriculture, including forestry and fisheries, and extraction of minerals, and also minerals in more general. So next slide, please. So what the companies will have to do. I mentioned there was less support for directors' duties. So you understood there are 2 elements of this proposal. It's the biggest focus is actually on corporate due diligence, and that's what was our aim. The companies will have to do due diligence regarding human rights and environmental adverse impacts, So you see there is no particular element on the governance, but this is covered more under director's duties. As I said, we are not fully aligned with OECD because the environmental adverse impacts are not covering all the adverse impacts. We have provided a concrete list of obligations for companies in the annex of the proposal, making a link to international conventions and trying to translate them for the companies to know what exactly they have to do in terms of environmental due diligence. So we follow, in terms of due diligence, we follow the 6 steps of OECD. So there is companies have to identify, prevent, and bring to an end all the negative impacts and in their own operation, in their subsidiaries, and in the whole value chain. I say whole because we mean really until the very last step of the value chain. However, as I mentioned, we wanted to make it proportionate. So we limited the value chain to established business relationships. So these are relationships which have a lasting duration or high intensity, and they are not ancillary to they are core part of the core business of the company. Let's translate it maybe this way. And also we have provided companies with a toolbox of appropriate measures. So there is no obligation of means, but obligation of result, but obligation of means. As I said, directors' duties are closely linked to due diligence. So the directors will have to set up and oversee the due diligence process, and they will have to report on it to the board. And on the top of it, there is an additional director's duty of care, which is a general duty that the directors need to take into account also human rights, climate, and environmental consequences of their decisions, not only in short term, but also in mid and long term. So really act in the best interest of the company. And as it was extremely difficult to include climate change in the due diligence because the Paris Agreement doesn't have a very clear obligation for companies, we have a specific regime for climate change only for the Group 1 companies, where the company has to actually adopt a plan to ensure that the business strategy is compatible with Paris Agreement. Next slide, please. Maybe we can skip. These are the 6 steps of OECD due diligence. I think I sort of already more or less guide you through. Maybe one just important thing to say is the communication, the step 5. Here we built on the Corporate Sustainability Reporting Directive, which is also a proposal of the European Commission. So we don't duplicate this, and it's not directly mentioned in our proposal for EU companies, at least. Next slide, please. So just to sum up, which obligations for which group of companies. So Group 1, the largest one, will have to do the full due diligence obligation for all. So it applies to all sectors. They will have to adopt this particular plan on climate change. They will have a CSRD reporting and both directors' duties, director's duty of care and director's duty to set up and oversee due diligence. Group 2, as I said, they will be phased in 2 years later to give them sufficient time to adapt. They will only have to do due diligence for severe adverse impacts, only in those sectors, those 3 groups of sectors which I mentioned. And the rest, and they will not have to do the climate mitigation. You will see that some of these elements are with an asterisk because these don't apply to non-EU companies. And I think this is very important for you to know that, for instance, we cannot request third country companies to do CSRD reporting. So there will be a specific regime. Third country companies will have to communicate, provide a statement, which will be further specified by a delegated act to comply with the communication part of on the due diligence. Next slide. This is, I mean, I will try to speed up. It's important element. So how companies will have to implement it. and what kind of enforcement we put in place, because we wanted to have something very ambitious and powerful. I put there also internal complaint proceedings, despite the fact that it's not fully enforcement. But it's very important also in OECD, this mechanism that actually there can be a complaint within the company, and it can be also done by certain stakeholders. Then we have put in place administrative supervision, where the member states will have to have a dedicated supervisory authority. They also have a complaint mechanism to start investigation. They will have to provide dissuasive and proportionate sanctions. And in order to harmonize, because this is a directive, so we cannot fully harmonize, we also provide a European network of supervisory authorities to coordinate and exchange information and try to really harmonize as much as we can the supervision. And last important element, as I already mentioned, we want to also make sure that victims can access the remedy. So we have put in place also civil liability. As I already mentioned, there is a difference between direct operation and operation, direct suppliers and indirect. So there are different regimes for them. There is also overriding provision, which means that also European law can be used even if the harm occurred in third country. But the burden of proof remains as usual under civil liability on claimant. And the very last slide, please. We want to make really effect on the ground, and we know this will have a lot of this proposal will have a lot of impact on business. So we really wanted to make sure that we also provide sufficient support for them. There is support at member state level, support at the EU level, and also, of course, support in third countries. So when we speak about supporting business, we don't speak about European business. We also speak about third country companies. There is also ongoing work on Team Europe, where we join forces with member states to provide further support. And we really want to also work on industrial schemes, how the industrial schemes could do a self-assessment, for instance, with our proposal, to make sure that they are suitable to be used. So there is a lot of coming up. There will be some guidelines to better explain the proposal. There can be a financial support, dedicated platforms, but we also think of sort of a one-stop shop which could provide information about particular supply chains and regions. So we really want to make this work between, sharing information between companies, between member states, between EU delegations, really, that you could access tools, but also information about particular regions and supply chains. And this is all from my side. I hope I didn't go too much about the limit, but it's extremely difficult to present this proposal in a very short manner. So thank you.
Thank you so much, Alexandra. Thank you so much. I think what resonated with me the most was the director's duty of care and creating a culture of no harm. Principles that are aligned, if not enshrined, in the UN guiding principles on business and human rights as well. So making this a new norm in offices and boardrooms, as well as sidestepping disengagement with third country suppliers. I think that was an extremely important point. I am now excited to introduce the session on the implications of environmental and human rights due diligence for Asian businesses. I think this is why we're all here. So given that SMEs make up more than 96% of all Asian businesses, they will continue to be confronted by diverging rules, standards, and expectations, while ensuring they have sufficient know-how, expertise, and financial resources. And with that, I would like to pass the floor to Ms. Ruenvadee Suwanmongkol, Secretary-General of the Securities and Exchange Commission of Thailand, on the strengthening of commitments to sustainable business practice in Thailand through the EHRDD work. Thailand has been exemplary in advancing the conversation around due diligence. The floor is yours, Ms. Ruenvadee.
Thank you, Jehan, and good afternoon and good morning. Good Niloy, good Alexandra, and Livio, and distinguished panelists, ladies and gentlemen. First of all, on behalf of Thai ACC, I would like to thank for inviting us to share our experiences in this area. I think the last 2 years, we have seen a lot of progress among Thai listed companies in this human rights due diligence and then the UN business and human rights. I think that there are the ecosystem and there are lots of enabling factors driving all the companies to move forward for sustainability. I have to thanks to the government policy and also the National Action Plan that clearly separate that listed company in the Thai capital market have to take UN general principle guideline for business and human rights, and having ACC Thailand to be a responsible entity. But I must say that ACC Thailand cannot act alone. I have to thanks to the stakeholder in the Thai capital market, basically the listed company, and then the UN Global Compact Network of Thailand. There are driving forces to make sure listed company already comply with this. And I have to thanks to the demand side as well, that right now institutional investor in Thailand, they look for a so-called responsible company. I must say this is a driving force of both demand and supply. As I said, that we have seen a lot of progress during the past 2 years. Business-wise, they look for sustainability rather than profitability at the moment. They look for long-term, not a short-term profit. The stakeholder, basically shareholder, they buy in already right now. And also the human rights due diligence, we can see it as a risk management process within the company. As Alexandra mentioned, the duty of director, duty of care, and the duty of diligence already make it to be important for all directors to make sure that the company need to have strategy for sustainability, to have the risk management process, and make sure that they already bring the ESG into the work process. Thailand, luckily enough, that we start having the good governance a long time ago. We asked all the listed company as a voluntary, the self-discipline to make sure they comply with a good governance. And then later on, we put up on the environment for the climate mitigation, and also the society social element later on. And so that with the self-discipline, as I said, the company themselves, they look into that. If you look into the ranking of sustainability worldwide, you perhaps already witnessed that the companies in Thailand growing in increasing number. Right now, if I'm not wrong, more than 20 listed companies rank under the Dow Jones Sustainability Index. I think that we quite achieved in terms of the largest listed company, but this is a long journey, Kun Jehan. We have to make sure that medium-sized listed company, they can also do the same thing like their big firms, SME right now, they're working together with us, but they're not yet become a listed company. So that we raise awareness among the mid-sized listed company together with SME, having the large company to be their mentor. We also bring up the best practices to ensure a medium-sized company to convince this thing is not too difficult to do, It's not too costly to do. You have to do for the sake of sustainability. This year is a good year for us. Not only the SEC already 30 years, anniversary on the 30 years, but starting from the 1st January this year, as perhaps you well aware, we require mandatory for the non-financial disclosure in terms of the sustainability. One, climate change, and two, the human rights. But again, we can't pick up this requirement in a day or two. We have been working closely with listed company for the last a year and a half to make sure that they're ready and then they're fully aware and then fully understand. We cannot only put up the regulation, but we need to have what you call training session with them along the line. And luckily enough, we have the law faculty, the Chulalongkorn faculty, to be the one who put up all the courses for this listed company. So that with this, I think that the awareness will around in the Thai capital market, action being done already, and only the things that we have to make sure that medium size and also all the supply chain of both largest and medium sized company comply with these two. Within the non-financial disclosure, as I mentioned, in short, one report, there is a voluntary EHRDD section on that, on this. If you look at the website, the Google, you put up EHRDD in Thai company. Surprisingly, there are so many companies, listed companies already have EHRDD statement in their report. You see, I think that we will welcome this improvement and the direction move forward to the sustainability. If I perhaps in my sharing at the moment, and then let Amanda to perhaps put up things, and I may come back afterward. I think that there is one question about the European proposed directive that I have to perhaps to share some thought or not. I'm not so sure. Thank you.
Thank you, Ms. Ruenvadee. I think that was certainly very enlightening and adds value to South-South cooperation and learning. We also need to start rethinking about who we refer to as shareholders, investors, or impacted communities. I do take note that you might have to leave the session for other commitments, but do correct me if I'm wrong.
Okay now, I'm okay now.
Okay, fantastic. Glad to have you here with us then. But thank you for your earlier sharing. And so now this brings us to the next sharing by Amanda Murphy, Counsel at Clifford Chance. Over to you, Amanda.
Thank you, Jehan. I'm very pleased to be joining in on this very important discussion today regarding the EU's proposed directive on mandatory corporate due diligence. And having heard the fantastic overview given by Alexandra regarding the salient features of the proposed directive, I'm going to focus on trying to discuss the potential impact of the directive on Asian businesses and companies. So I'll start this just by drilling down into really the two ways in which the directive is likely to have an impact on Asian businesses. And by the term Asian businesses, I mean companies incorporated in an Asian jurisdiction. So the first way is by direct application to certain large Asian businesses with operations in Europe. And the second is indirect means to a much larger network of Asian companies who sit within the value chain of an EU or non-EU company, which is subject to the directive. So, which I refer to as a covered company. So another smaller business, including SMEs, who fall within the value chain of a covered company. So in respect of the first avenue, direct application, it's quite clear from the text that it is intended to have extraterritorial scope in certain respects. And as Alexandra pointed out, there's about estimated to be about 4,000 non-EU companies that could be subject to this directive. And I guess the amount of how many of these 4,000 non-EU companies are Asian will ultimately depend on the criteria that's listed in the directive. So looking at the criteria, which Alexandra already went through regarding the Group 1 and Group 2 companies, relating to the value of their turnover. For Group 1, and then for Group 2 companies, it'll be based on lower turnover, but if they have more than 50% of their turnover in the EU generated in a high impact sector. And I would just note that I think a number of the sectors in which the Asian businesses are major global exporters do fall within those identified as high impact sectors. So this particularly includes, for instance, textiles, clothing, agriculture, fisheries, and trade in other raw materials. Interestingly, I note that the directive doesn't yet include or extend to electronics and finance, which are also large sectors for Asian businesses. So it'll be interesting to see if there's other comments flowing as the directive passes through the Parliament and Council. I thought it might be useful as well just to give an idea of the size of trade currently conducted between the EU and Asia, to give some context to these figures. So in 2020, about 44%, so the majority or the largest sector of EU imports came from Asian countries, whereas only 13 of EU imports came from North America. And similarly, the main destination for EU exports in 2020 were other European countries first, with 37% of total exports, but quite closely followed by Asia, receiving 30% of total EU exports. And according to a recent McKinsey report, Asia was the destination for $1 out of every $2 spent in new investment over the past decade. And Asian companies now account for 43% of the world's largest 5,000 companies. So it is really very, very probable that a number of large Asian businesses will fall directly within the scope of the EU directive. And here I'll just note that it is quite interesting that for the companies which fall within this direct scope and have turnover of more than 150 million in the EU, they will have to comply with the quite novel requirement, I think, to adopt a plan regarding limiting global warming and planning for a sustainable transition. So I think that's quite a new, a mandatory sort of compliance requirement for certain companies in the APAC region. So moving on now to the second way, and I think probably the broader way and the more important ways to which this directive will have an impact on Asian businesses. And this is through the indirect application. And this is ultimately through the performance of the due diligence obligations by the covered companies, i.e. those to whom the directive does directly apply. So Article 6 of the directive is of quite importance here. And there's two sort of key terms that are used in that article that are useful to focus on. The first is the use of the broader term value chain rather than supply chain. So the value chain is broadly defined to include not just supply of goods, but also the use and disposal of the product, as well as related activities of upstream and downstream established business relationships. So this broader scope ultimately means that it's more likely that some Asian companies will fall within the scope of the due diligence investigations required to be conducted by the covered companies. The second term, which is quite novel in this directive, is the term established business relationships. So this is defined as a business relationship, direct or indirect, which is expected to be lasting in view of its intensity or duration, and doesn't represent a negligible or merely ancillary part of the value chain. And this assessment as to whether a relationship between an EU company, for instance, that is subject to the directive and a company in its value chain in Asia is to be reassessed every 12 months. So, I note here that there have been suggestions that it might be more useful or better for the directive to focus on potentially the seriousness of the risk rather than the proximate nature. And in this respect, the UNGPs do have responsibility for companies in all sectors and industries to respect human rights. However, as currently drafted, many situations can easily be envisaged where covered companies regularly source textiles or raw materials from suppliers in Asia or have value chains originating in Asia. So moving on to how, I guess, these companies will, I guess, have that trickle-down effect of the due diligence requirements. Article 7 is quite a central provision in this respect. So that one requires, amongst a number, it requires covered companies to undertake a number of prescribed actions. One of these is to seek contractual assurances from business partners that they will comply with the covered company's code of conduct, and also that they will seek corresponding assurances from its partners. So this is known as sort of contractual cascading. So, it's very likely that Asian companies will see much more, if this directive is passed, the introduction of these types of clauses in their contractual agreements. And it is definitely something that we are already seeing as lawyers, myself as a lawyer, with clients requiring or requesting that these types of clauses are already introduced. And that's really just based on the voluntary standards at the moment. And really, this is where I think that the most progress, or the real progress, will be made in addressing these human rights and environmental impacts in Asia, and that's through the casting the due diligence obligations, much broader than the companies who are directly covered by the directive. And I note here that there's no size limitation on the companies within the value chain who might be subject to help report up to the covered company. And there's a number of provisions which anticipate that the covered company might help smaller SMEs in their value chain comply with their obligations. So, for instance, in Article 7, it requires that covered companies provide targeted and proportionate support for an SME with which the company has an established business relationship, where compliance with the code of conduct or the preventative action plan would jeopardise the viability of the SME. And so the consequences for Asian businesses as well, where a potential adverse impact is identified but can't be mitigated, are also potentially severe. So Article 7.5 anticipates potential suspension of commercial relations and ultimately termination. So there are some very real business world, commercial world ramifications, I guess, for non-compliance through the value chain, even if those companies aren't directly covered by the directive. So ultimately, we're sort of getting behind on schedule. So what does this mean for Asian businesses in sum? Effectively, it is likely that companies in the Asia and APAC region will be indirectly forced to modify their processes to meet their requirements. And out-of-scope companies should expect dialogue throughout the value chain as covered companies start preparing for their new responsibilities and increased director duties. So this could result in changes to their contractual arrangements, maybe to their codes of conduct as well, and also a requirement for certified or conducting certified or independent third-party audits to assist with due diligence requirements. Asian businesses should seek to understand the requirements and the basis of a lot of these principles through the UNGPs and other relevant standards. And as I mentioned before, human rights due diligence is already very much a part of transactional due diligence for our clients, and we've already been often required to include express warranties or terms in contracts requiring compliance with human rights and environmental due diligence obligations. And just before I finish, I just thought it might be used just for some food for thought, maybe for questions later, just to potentially note some of the counter arguments on, and I think it'll be interesting to evaluate whether this directive could lead to some of the negative impacts in the Asian region, which the EU directive was intending to avoid. And by this, I mean, legal certainty, consistency, and the need to avoid an uneven playing field. And it's certainly possible that if only some and not all Asian companies are captured, directly or indirectly, by the directive, then those companies indirectly subject to heightened DD might face higher transaction costs, might be placed at a competitive disadvantage vis-a-vis companies who are not subject to those obligations. So I think it would be good to monitor these effects and potentially remedy or make sure that there is legal certainty and consistency across the board. So I think that in that respect, that the EU has really set the tone. And for hopefully other states, and is intended that other states will follow suit, and this will avoid those potential adverse issues regarding fragmented regulation and an uneven playing field. And so I guess in conclusion, that it's unavoidable that given the integrated cross-border nature of international trade and commerce these days between Asia and EU, that the EU directive, if and when passed, will definitely extend well beyond the EU and firmly into Asia.
Thank you so much, Amanda. And thank you also for your sharing on counter arguments. I think, that was an extremely important point. Some things that we have also thought about in our work as well. I would also like to especially thank you, as well as your team at Clifford Chance, for all the hard work developing the human rights self-assessment training tool, which is available online on our website. Clifford Chance has been instrumental in helping UNDP to define 99 business-related human rights risks in priority industries. These risks were linked to international human rights instruments and also to the SDGs. And based on your work, I'm happy to report that the tool has reached over 1,700 return users in over 100 countries. So very much thank you to you and congratulations. I would like to now move to the next session and invite Dr. Aishah Bidin. But before that, I would also like to mention her recent appointment as the Malaysian representative to the ASEAN Intergovernmental Commission on Human Rights. Congratulations, Doctor, from all of us. And now over to you.
Okay, thank you very much, Jehan. Yeah, good morning, good afternoon, and also good evening to the other panelists and delegates as well. So this is a very hot topic at the moment. Yeah, and of course, with the launch of the directive, this signifies EU stepping in a leadership position on the need for mandatory measures to increase the dynamics of human rights and environmental due diligence, which is very much, I think, crucial as part of the bigger agenda of promoting business and human rights. Now, within this context, I think prior even to these developments, we have seen how modern slavery provision has actually affected the regions because of the developments of legislation relating to supply chain that are adopted by various countries in the world, America, Europe, and even Asia Pacific. And this reflects in terms of the momentum behind the implementation of mandatory reporting and human rights due diligence requirement around the world. So in other words, this initiative are very much welcome. We assume that this progress is coming from one step to the other. So looking back again at the features of this particular directive, it has a extraterritorial effect. It's applied to non-EU companies which actually fulfill certain threshold. It's voluntary, but at the same time, it's also not applicable to SMEs. Now, for the directive to be achievable and of course sustainable, significant opportunities must be considered, especially across the region. In other words, there are still major steps and measures, and even to an extent, maybe some preparedness to be taken by the respective government, a regional counterpart in the supply chain process. Now, I'll raise this issue in the context of this region, especially in ASEAN and also to Malaysia. Now, in Malaysia, of course, EU is the 5th largest trading partner of Malaysia after China, Singapore, South Korea, and the US, accounting for about 7.4% of the country trade total. And in 2020, Malaysia becomes EU 20th largest trading partner on goods, but not so much on services. So certainly to a certain extent is being identified by Amanda just now. There's about roughly about 4,000 companies, non-EU companies, which are affected. So I think we are actually within that particular numbers as well. So my key point would be, what are the current situation and challenges in the region? And how do we go forward in adapting the changing landscape of this human rights due diligence, especially this directive in particular? So the current position, I think, for once, we are very clear that most countries in ASEAN region does not have specific legislation on mandatory human rights due diligence. Nevertheless, as a result of the development of the modern slavery legislation, we can see that it has actually affected most countries in ASEAN, especially because due to the nature of trading partners, and which resulted in some companies have attempted to adopt modern slavery statement in their financial reporting process, which includes disclosure requirement and the supply chain statement as well in their business operations. So I think there's already a start in terms of the pattern, in which some companies have followed a suit to what you call implement this human rights due diligence in the supply chain process. So the closest related legal framework obligation is, I think, in ASEAN countries, it would be the anti-trafficking laws, because there are provisions against forced labor and so forth. And within the context of ASEAN, we have the ASEAN Human Rights Declaration, in which Article 13 prohibits, emphasizes the prohibition of trafficking, and Article 27 actually emphasizes very much on the rights of employees, the rights of foreign laborers, and so forth. So we also, I think, observe that many ASEAN countries would have their own anti-trafficking laws, which affect indirectly the supply chain context. And also many countries in ASEAN also have their own respective special task force established at the national level. We also observe that as a result of some what you call liabilities, right, committed by some companies in the region, there are numerous what we call withhold release orders already by the U.S. Custom and Border Protection (CBD). Also to some Malaysian companies over alleged forced labor practice, which is actually signifies an urgent signal to Malaysia to immediately put and place effective measures to circumvent and remedy these forced labor practices. Now, of course, when you talk about due diligence, one particular aspect would be the disclosure requirements. Of course, we have to include the role played by regulators in the region. Now in Malaysia, of course, sustainability reporting is also one of the facets already adopted by Bursa, the stock exchange. Of course, this is very much for public listed companies. We have at the moment about 1.3 million Malaysian companies which are registered in the Companies Commission of the Malaysia, and about 96% of this would be SMEs. Again, I think there's a very large portion of SMEs who normally sometimes are actually involved in the supply chain, which are being precluded from this directive. So this is also perhaps some of the issues that would be good in terms of discussing later in terms of the repercussions. Now in Malaysia, again, we have provisions under the Companies Act in terms of the disclosure requirement with the new business review reporting under the Companies Act. This can be seen as an extension to the social and human rights issue relating to reporting. But the term used is not due diligence. The term used is disclosure requirement. So legally per se, it is not equivalent with the concept of due diligence under the second pillar of UNGP. It's very much in terms of just disclosure requirement. So I think within this context, one of the opportunities interesting that was raised by Amanda and Alexandra just now is the opportunity to impose human right due diligence based on directors' duties. Because in most ASEAN countries, we have our Companies Act legislation, which normally would have provisions on directors' duties. And in Commonwealth countries like Malaysia, Singapore, and so forth, the directors' duties in relation to the meaning of the best interests of the company can also be extended widely, interpretation to perhaps also include a direct due diligence as well. And this will be, I think, a good tacit test, to that we can actually extend and spread around in terms of incorporating human rights due diligence within the legal provisions. Also, one observation among the ASEAN countries is that many countries in the region have not fully adopted the second pillar, which is actually the ethos of the due diligence process under the UNGP, apart from Thailand, which is, of course, as you mentioned, the exemplary case in this region, which is the first country to have an NAP on BHR. Few other countries are still in an ongoing process at different phases and tangents, such as Indonesia and Malaysia and Myanmar, of course. We are still working at different phases on the National Action Plan on Business and Human Rights. So although the UNGP is currently the most authoritative document on BHR, it is still considered not a legal binding, which may be considered as one of the non-push factor for the commitment of the state. So this soft character of this instrument will entail that they do not create legal binding obligations for other states or companies. So in the absence of implementing regulation, the corporate responsibility to respect remains very much a moral obligation, which is rooted in social expectations rather than a legal obligation. So what we can see now is that the fulfillment is very much rely on voluntary approaches by companies on the second pillar. But on the other hand, on the contrary, we also have seen good practices in various sectors. For instance, we have seen human rights due diligence tools on ethical recruitment in Malaysia, adopted by some companies. Sunway Group, which is one of the largest construction company in Malaysia, are now committed to net zero target, achieving a net zero carbon emission by 2050. And of course, the regulators are crucial in the country in gradually implementing stricter ESG standards, because this is important for investors to increasingly look at company sustainability and related tools to guide their investment strategy. So linking with the ESG, I think within the context of GLC companies is also important because we have Guiding Principle 4 of UNGP in which GLC companies, or in some countries it's referred to as SOEs, can play a very important part in promoting sustainability objective. So we foresee that GLC might be, perhaps the first tier perhaps in promoting such agenda. There are also positive signs in which I think we have seen, like for Malaysia, the launching of the National Action Plan on Forced Labour recently, and of course last year, and I think this week, as being mentioned by Mr. Niloy just now, Malaysia has just formally adopted Protocol 29 of the ILO relating to combat forced labour. So Malaysia will be the 5th country in the Asia Pacific to ratify P29 and the 2nd country in ASEAN besides Vietnam. And I think it's also interesting to see that this week, I think the lower house in Parliament, Dewan Rakyat, is actually still debating in terms of the amendment to the Employment Act, which also I think observe a next step further in reviewing in terms of the rights of employees and so forth. So in other words, there are gaps, there are challenges in the current existing framework in terms of human rights due diligence, what more mandatory human rights due diligence. So how do we address these issues? How do we go forward? Now, I personally have identified very briefly 6 factors, which I think will be good for a start for further discussion. One is that in imposing human rights due diligence and even a mandatory human rights due diligence, it is important to determine the capacity and the ability of the use of monitoring, investigation and enforcement powers of the competent national authorities to ensure that all companies are subjected to the regulatory regime complying with the new duty. So the role of these administrative authorities is important. Do they have are they well trained? Are they well equipped in terms of resources and so forth? This is something which is of course crucial in countries in the ASEAN region. Capacity building, training and so forth. Number 2 is that managing human rights risk and impacts in supply chain can be extremely complex. And of course, supply chain can involve hundreds of thousands of suppliers and several tiers, with suppliers typically providing services to more than one sector. So I think the issue here is, to what extent can we succeed in tracing in terms of the accountability of the supplier? This is still remain one of the toughest, I think, area in UNGP, especially the second pillar. Number 3 is actually resolving the issue in terms of the absence of direct market pressure against suppliers, because we can see that the trend is always in campaigning and lobbying and advocating for the banning of certain products that linked with human rights violations. Normally the target would be large corporation, which we understand what's the reason. But what is more important is that the suppliers, in irony, the suppliers of these large companies are actually small, medium enterprise. And they are part of the supply chain. Most of them are small and medium enterprise, but they are not members sometimes of the sustainability standards, such as the RSPO. So in other words, this is perhaps one of the areas that's important to look at. Certainly, I think there are issues to promote certification standards and so forth.
Prof. Aishah, I'm so sorry. We have about 30 seconds left, if that is okay.
Yeah,
thank you so much.
Coming up,
Thank you.
I think there are 2 more factors. The other one is actually addressing gaps in the governance practice. And I think this point is very, very important in terms of a lack of government leadership in addressing governance gaps, because you need coordination from the various levels. And of course, promoting access to justice issue is still a very major issue in this region, especially when it comes to public participation. And finally, enhancing procedural issues on environmental cases, which is the remediation process, grievances mechanism, and so forth. So I have to say, in conclusion, the momentum is there, right? The steps has actually has been charted by way of modern slavery legislation. But what is important is that business who have started it voluntarily should be encouraged to do more, and to ensure that the human rights due diligence is more effective. And businesses who are not ready yet should start now and strive to implement that is consistent with UNGP. So I think this is the point, very important. Organizations such as UNDP role to promote awareness, advocating the adoption of human rights due diligence practices among the business in ASEAN and other regions. Thank you so much for attention, and sorry for taking a little bit extra time. Thank you.
Thank you so much, Doctor. We noticed there's a couple of questions, quite a number of questions that you may see in the Q&A, perhaps also in the chat. For any speakers, feel free to answer some of these questions if you think you are in the position to do so. We will have a Q&A session later. We will have Alexandra come back in, as well as Ruenvadee. So hopefully, we can start that answering process sooner before the Q&A session. So we will now hear from Bapak Bahtiar Manurung, the Operations Director of the Foundation for International Human Rights Reporting Standards of Indonesia, on his experiences working on EHRDD in the country. Over to you, Bapak.
Thank you very much, Jehan, for the introduction. First of all, I want to thank UNDP and European Union for having me as a speaker at this event. I'd like to start by saying that we at FIHRRST warmly welcome the EU proposed directive on corporate sustainability due diligence. We welcome the proposed directive as we believe it will accelerate the uptake of HRDD by companies around the world, including in Indonesia, which, as we all know, has been significantly slow until today. So the 2022 report of World Benchmarking Alliance on Social Transformation Baseline Assessment reveals that of 1,000 largest companies in the world, including 355 in Asia, only 7% of the companies meet the HRDD indicators. And our study, first study on the respect of human rights in 100 largest public companies in Indonesia in 2019, found similar results. We found that only 3 companies disclosed their commitment to conduct human rights diligence. And of that 100 companies, only 4 companies that already have human rights policy with reference to UN guiding principles. So the proposed directive will likely advance the adoption of human rights diligence in Indonesia and in Asia, because as has been mentioned by the previous speaker, Amanda, the scope of the proposed directive covers non-EU companies, right, including Asian companies, if they meet the turnover threshold as stated in the directive Article 2.2. And for Asian companies, Indonesian companies that are not within the proposed directive, they will also be indirectly impacted, right, by the proposed directive if they are part of the value chains of the EU companies. And I'm specifically interested in the clause of the directive that says that if EU companies discover that business partner Asian companies in their value chain fail to prevent potential impacts or fail to end actual adverse impacts during the EHRDD process, the commercial relation can be temporarily suspended or terminated. So Asian companies certainly do not want their business with the EU discontinued. So although only a very few Indonesian companies that have actually carried out human rights due diligence, but we have seen a growing awareness of Indonesian and even Asian companies that they need to respect human rights through the uptake of EHRDD if they want to stay competitive. This is due to a number of recent developments that relate with business and human rights, right? The first one is the rise of ESG, environmental social governance, as has been mentioned by Dr. Aishah before. ESG-oriented investment has been growing rapidly. And due to COVID pandemic, investors now have been emphasizing on the social pillar of ESG, especially human rights aspect. So we've seen that companies globally, including in Indonesia, are now racing to improve their ESG rating and performance, including human rights performance, to have access to the ESG-oriented funds. The second development that we saw is the recent update of the GRI standard. GRI standard is a global standard for sustainability reporting, right? Recently, the update requires general disclosure on EHRDD, human rights due diligence implementation that will be effective 1 January 2023. So GRI standard used by 10,000 organizations worldwide, including around 700 companies in Asia. 83% of Indonesian companies' sustainability report use GRI standards. So with this new update, we believe that companies in Indonesia and other countries are aware that they need to start conducting human rights due diligence if they want to continue using the GRI standards. The last development that we see has built awareness of companies to carry out human rights due diligence is the growing stock exchange legislation on sustainability reporting that demand human rights disclosures. According to the Sustainable Stock Exchanges or SSE report, the report mentions that 16 stock exchanges already refers to UNDPs in their guidelines, including 2 stock exchanges in Asia, Malaysia and Bangladesh. 7 stock exchanges require human rights due diligence reporting, mostly European stock exchanges. In Indonesia, we have been encouraging the Financial Service Authority, OJK, and the Indonesia Stock Exchange to require public companies to disclose EHRDD implementation in their sustainability reports, which unfortunately has not been included in OJK's regulation on sustainability reporting standard. And as a member of the Indonesia Task Force on Business and Human Rights, we continuously advocate that Indonesia Stock Exchange is included as an implementing partner in the upcoming Indonesia National Strategy on Business and Human Rights. So with these developments and the EU proposed directive, so a smart mix of voluntary and mandatory initiatives, we will likely see an increase in the EHRDD uptake in Asia soon. I will close by sharing with you our experience in carrying out human rights due diligence. So last year, a few companies approached us asking to help them to carry out human rights due diligence. Again, as I mentioned before, driven by the request of investors for the companies to improve their ESG performance. We see similarities between companies that ask our help to carry out EHRDD all of the companies already have human rights policy that refers to UNGPs, and their human rights policy mention their commitment to carry out human rights due diligence. And all of the companies commit to carry out stakeholder engagement throughout the EHRDD process. Last year, we were fortunate to be assigned by UNDP to implement a pilot project assisting Indonesian companies to carry out human rights impact assessment of their operations during COVID-19 pandemic. The pilot project used the UNDP's tool, which is available on the UNDP's website, the Human Rights Due Diligence and COVID-19 Rapid Self-Assessment for Business. At the end of the Rapid Self-Assessment pilot project, we saw an improved commitment of the participating companies in respecting human rights and improved commitment for them to carry out a full-fledged human rights due diligence in the future. So thank you for the opportunity to share our experience in carrying out human rights due diligence in Indonesia, and I'm happy to answer any questions later on.
Thank you so much, Bapak. So in the interest of time, we will go to our final speaker for today. I would like to invite Bagal Ochko, Deputy Chairperson of the Mongolian National Chamber of Commerce and Industry and President of the International Women's Federation of Commerce and Industry of Mongolia. Over to you, Bagal.
Hi, hello from Mongolia, and distinguished panelists and speakers and guests. Very good morning and good afternoon and also good evening. First of all, congratulations to all of you who are participating from all continents to this dialogue between Europe and Asia and sharing your country's experiences and valuable information about implementation of UN guiding principles on business and human rights. We have heard interesting perspectives regarding the proposed draft of the European Directive on corporate sustainability and human rights due diligence. Its relevance and immediacy, particularly in Asia. And I'm pleased to be able to share with you our experience and reflection from Mongolia on behalf of the Mongolian National Chamber of Commerce and Industry and also International Women's Federation of Commerce and Industry, Mongolia. And I'm here attending this forum as a member of the Executive Committee of the National Action Plan on Business and Human Rights. I'm sitting this working group on behalf of the National Chamber. Since Mongolia is one of the GSP Plus beneficiary country with complete duty suspensions for products, we appreciate that a specific norm on human rights due diligence obligations for the businesses is being proposed in the European Union. Since human rights due diligence is a new sector and new service in Mongolia, in order to provide the right information to the private sector or business entities, we've been organizing trainings for business entities which provides information on environment and business and human rights, including how business and human rights due diligence are conducted and its important impacts. In the beginning, some businesses looked at the EHRDD as if it's going to create additional work and extra expenses. But this tendency is changing as knowledge and information are disseminated. We're inspired to see that our business entities who receive the information and training are understanding and advantages of human rights due diligence because it influences on the company and its business stability, increase in investment and export opportunities, and of course its positive impact on the value of business, society, and the country. Starting from the 2021, IWSI Mongolia started cooperating with the MDS Hanflex law firm in Mongolia, and we introduced the due diligence service in the field of business and human rights for the first time in Mongolia. We used the UNDP Human Rights Due Diligence Facilitating Guide as a reference. And we are conducting the business and human rights due diligence at the Apple company, JSC, a leader in Mongolia's liquid industry, as a part of business and human rights due diligence project. It's delivered as a consulting service. Apple company operates all over Mongolia, has more than 2,000 employees, and it cooperates with many suppliers in many fields, such as agriculture and services. There is no doubt that this will bring many positive changes in the Mongolian business sector. By Apple company introducing the principles of business and human rights and being an organization who respect human rights. It's hoped that this work will be beginning for the Mongolia's large national corporation to train the influence of the suppliers and partners on introducing business and human rights principles. As a result, we've been seeing practice that large companies are a key tool to strengthen and influence other companies, especially small, medium, and SMEs.
Apologies, Baigal.
Yes.
If you could speak louder. Sorry, I think it's a little bit soft. Suddenly.
Okay, sure.
Thank you so much.
Supply chain companies. Okay, so initially perceived human rights due diligence as an additional form of control, overload, and coercion. How the private sector respond to human rights due diligence depends on how we explain it. All the general knowledge is better than its past. We still have much to learn about human rights due diligence methods. Therefore, I would like to express my willingness to develop environment and human rights due diligence in Mongolia with the full support from all of you who have shared your good experience. Actually, it was a new learning for ourselves too. There is a lot of work to be done in the private sector, such as disseminating this knowledge to more businesses, raising awareness of the importance of the EHRDD, involving more businesses and then creating conditions and for business organizations to influence each other, providing knowledge to supply chain and the suppliers, and taking action that mainly focuses on preparing for large corporations to ask from their suppliers to free of human rights violations, to prevent human rights violations and adverse effect, and then to restore and improve violated rights. Considering Mongolia's specific, the country's economy is based primarily on the mining and the agriculture sectors. There's a growing need to conduct environment and human rights due diligence. By conducting effective and genuine human rights due diligence, it will be an important support and important step for businesses to participate in the international economic incentives and then programs aimed at promoting sustainable development and good governance, such as GSP+ to export and cooperate internationally to reduce operational risk. At the end, I would like to reiterate again that business human rights and human rights due diligence are new concept of the businesses. And the current EHRDD initiatives are also new experience for everybody. That's why it's important to build national capacity and expertise to facilitate and support EHRDD among the private sector. And I would like to take this opportunity to thank the European Union and United Nations Development Program for the continuing support and cooperation for Mongolian government. Thank you.
Thank you so much, Ms. Baigal. Now, in interest of time, we would like to go straight into Q&A. I would like to therefore invite my colleague Zolo, BHR specialist from Mongolia, who will be assisting with all your important questions.
Thank you, Jehan. We have a number of questions, but most of them were also answered during the speeches. So we are delivering some questions that were not answered yet. So first question is to Ms. Ruenvadee Suwanmongkol. The question is, what kind of human rights issues companies are required to disclose under the Thai regulation? Are they specified to comply with the UN guiding principles? And where can we get this information?
Hello. Hi, I'm Ruenvadee here. Right. Can you hear me? Shall I answer now? Thank you, Akiko, for the question. I think that considering the time, you can look up to our website. But the human right that Akiko asked, it depends on the company's operation, but basically deal with the labor law, the production law, so on and so forth, like that. Like what we have seen, that the use of the about the labor law, basically on that, you know.
Thank you.
Yeah, may I add one thing during my session? I think I forgot to mention that for the EU proposed directive, I think we are welcome because Thailand having the trade with the EU, we are, I think that the fourth largest trade partner. I think the preparation for the Thai listed company now, which EHRDD make a listed company already prepare themselves. I think that they are having a trade with the EU country. Thank you.
Thank you. And there are questions that could be directed to Dr. Aishah and Amanda. The questions are, actually I have two questions here. The first one is, what role can European embassies and chambers of commerce can play in ensuring compliance and monitoring in their supply chains in Asia? Second question, it's also like, it's more a suggestion also. Proper due diligence with integrity is extremely important to ensure that companies are financially, technically, environmentally, and socially capable or sustainable. It is therefore important to have a fit and proper person test criteria to regulate and eliminate blacklist the entry of incompetent, untrustworthy, and unethical companies, particularly in the extractive sector. And would like to hear more on this suggestion. This is the two questions I have to Dr. Aishah and Amanda.
Okay, perhaps maybe I can try to respond to the one relating to the policy making. I suppose within the context of policy making, because this would be one of, in fact, the challenges, especially the different approach taken by various states in the ASEAN region. It will be very important, as I mentioned just now, in order to address this particular issue, in order to ensure the readiness of the particular situation, the main key players must be ready. And of course, if you refer to the UNDP, it has to be the state, it has to be the business entities, and also it has also to be the other sectors as well, the non-state players. So I think that's in that context, I think having promotion in terms of capacity building, dissemination of information, especially from the embassies, related embassies, and also from the chambers of commerce, from the EU side, will certainly, I think, will be a good pathway to chart out in terms of supporting and brainstorming what are the real problems actually faced by the state or by the government, because in most situations, even we can see that even a particular situation of decision, it requires various agencies and various ministries to come up with a consensus. So I think more platform should be provided in terms of promoting the agenda, promoting awareness to the policymakers, very importantly to the state in terms of their duty to protect in the whole agenda. So I have to say that the embassies and the chambers of commerce in the particular region, especially from EU, in this region, in the ASEAN region, is important to play their part in providing the understanding for the policymakers. That would be my response to that question. Thank you.
Amanda, do you have any response on that?
Not so much a response to that, but I thought I would tackle the second question which you posed, and I quite liked this question when I read it, and it's the concept of integrity due diligence, and should we have a fit and proper person test to eliminate sort of unethical companies. I guess fundamentally the purpose of environmental and human rights due diligence, as well as broader due diligence that you would normally undertake in companies, is in some respects ultimately an integrity due diligence, because companies, as everyone knows, act through people. They act through individuals who are on the board of directors. So in many respects, regulating their, I guess, behaviour is covered currently in some extent from existing directors' duties. And that's why I did find quite interesting the new expansion of these duties in the directive, in Article 25, which could go some way to sort of bolstering these the requirements of directors, because, as I said, it's really through these individuals that, from the head of the organisation, that the trustworthiness of a company will be determined. And I think in this day and age, if certain, particularly shareholders or other stakeholders, identify that the board in these companies do not meet these standards, they will, there's a lot of activism, and they will take action to either try to remove those directors or affect some other sort of change. So I think a recent example in Australia of where that shareholder activism or sort of response into a HR potential mismanagement issue was with Rio Tinto, and the way it's responded to the destruction of the Yukon Gorge. So whilst in that respect they sort of technically complied with their obligations, there was that sort of sense of backlash that something further needed to be done. So I think that's where stakeholders and shareholders are also quite important, coupled then, I guess, with the obligations of directors to act ethically. And that kind of, I guess, is where I would sort of consider that the fit and proper person test comes into it from a personal perspective in a company.
Thank you all for your responses. And in consideration of time, I think I'll put the last question, and this is addressed to Bahtiar. And we are requesting you to answer this question from the CSO perspective, particularly in terms of the monitoring and evaluation of the directive implementation. So the question is how to ensure that human rights due diligence commitment and process made by listed companies are really implemented, that risks are mitigated and avoided, meanwhile impacts are remedied. How should the monitoring and verification process go? This is the question to you, Bahtiar. Thank you.
Thank you for the questions. Instead of answering the questions, I would like to just give my thoughts on the previous questions, which is what makes a proper human rights due diligence. So in my opinion, what makes effective human rights due diligence consists of 4 points. Human rights due diligence has to be an ongoing evaluation, not a one-time exercise. So not only pre-contract signing, but also during the period of the project. The second key to a proper and effective human rights due diligence is stakeholder engagement throughout the 4 steps of EHRDD, which is identification of human rights impacts, the address of human rights impact, tracking human rights, the action taken, and also communication. Stakeholders need to be engaged, particularly vulnerable groups, such as people with disability. And then for the last thing, for the successful, effective human rights due diligence is that human rights due diligence has to include gender lens human rights due diligence, which means that the human rights due diligence has to engage women throughout the 4 steps of EHRDD. I may not be able to answer the question, but hopefully that can add value to the previous question.
Thank you very much. So we'll stop the question and answer session here. And I hope that there will be more opportunities for other questions to be answered in the future during the similar dialogues and events. Thank you.
Thank you so much, Zolo, and thank you to you all for these very important questions. We will be taking note of the questions that could not be answered today. And if I may ask my team, maybe Belinda, to add our contact, maybe our email into the chat box. Feel free to get back to us. You know, the specialists in every country are really here to help answer some of these questions. Okay, so as we move towards, we are at the end of today's event, and we have gone a little bit over time, but it has been, you know, really fulfilling in a sense that it has been fully packed with learnings and great examples to try in our own work. So finally, I would like to now pass the floor to the one and only Livio Sarandria, UNDP Business and Human Rights Advisor at the Bangkok Regional Hub, who we may all be familiar with as the face of BHR Asia. Over to you, Livio.
Thank you, Jehan, for the generous presentation, and greetings from Bangkok. Now, in closing this very informative, I must say, dialogue, let me start by thanking all those who joined us, of course, participants, speakers, and our wonderful country specialists, and most importantly, you, Jehan, for having moderated this discussion. Allow me also to make 2 special mentions. The first to Professor Aishah Bidin, longtime friend of our project, to personally congratulate her also for the recent appointment as AICHR representatives for the government of Malaysia. The second special note is for Kun Pichamon Yeopantong, also recently appointed member of the UN Working Group on Business and Human Rights. She will replace, in a few weeks, in fact, Professor Surya Deva. It was very nice surprise to spot you among our participants, Kun Pichamon, and a great pleasure to have you with us. We very much look forward to working with you during your mandate with the UN Working Group. Gratitude goes, of course, also to the European Union, our partner in the implementation of this business and human rights project since 2020. I have very much enjoyed the presentation from Alexandra today, so thank you for that. Your introduction to the hopefully soon to be adopted Corporate Sustainability Due Diligence Directive was very clear, informative, and timely, I must say. Timely for 2 reasons, which in my view stand out, having listened to the comments from the other speakers today, and also based on my conversation that I have on a regular basis, almost daily basis, with companies and governments in Asia. Number 1, the EU is no doubt one step ahead of other regions on business and human rights, in particular on human rights due diligence policies and norms. But it's clear also that in Asia, companies, and not only European companies based in Asia, but also Asian corporations, are not just waiting for this evolution to happen. They are learning, preparing not to be left behind, and eventually be able to manage the potential risks to be disconnected from the value chain of European companies, as we have heard today. This risk, as we have acknowledged today, is not only for large companies, but also for SMEs. Number 2, the inspiration coming from Brussels is encouraging governments in East and South Asia to develop also their own human rights due diligence policies. EU governments will soon started adopting NAPs in 2014, and Asian governments follow suit. 3 NAPs have been adopted, 5 more are in the work. I am seeing a similar trend on human rights due diligence. The EU member states that started adopting specific guidance and norms in 2017, from 2017 on, and we are now seeing encouraged the signal in Asia. For example, the government of India, they adopted the guidance for companies on responsible business conduct in 2018. The government of Thailand, as we have heard from our dear friend Ruenvadee, looking at EHRDD reporting for listed companies. And most recently, we all welcome the important announcement of the government of Japan to fast track the development of the human rights due diligence guidance for all Japanese companies. I understood that this guidance will be launched before summer, and I consider that a very, very important development. Now, in these examples, I see trading partners and companies part of the same value chain, which are talking to each other, interested in speaking also the same language for what it is eventually a win-win situation for businesses and rights holders in both regions. Now, let me leave you with a suggestion or a wish, if you like. One of the things that, in my view, will make the upcoming EU norms on environmental and human rights due diligence so groundbreaking is the fact that they will apply to an entire region and beyond. They will express consensus on this subject of 27 member states. Now, it would be great to start a process of consensus around the need for EHRDD across regions or sub-regions in Asia. So with NAPs being adopted or in the works in Indonesia, Malaysia, and other countries, it would be great to have these countries leading on the development of an EHRDD policy, eventually applying, for example, to the entire territory of ASEAN. I realize that this might not be an easy task, but I also think that the progress made in the last 4 years should encourage us to be ambitious. UNDP looks forward to finding entry points to discuss such a ASEAN framework, perhaps in the context of the work already done by AICHR on business and human rights. The not so hidden hint is, of course, for Professor Aishah. I'll stop here. I thank you all again for your participation today on behalf of UNDP, and I look forward to further conversation on this important topic. Thank you.
Thank you so much, Livio, for that wish. So on behalf of the BHR Asia team, I would like to express my deepest gratitude to all speakers and also to all of you who have attended from Europe, Asia, and all corners of the world. We truly appreciate your time and your effort for being with us. Before you go, I would like to kindly request that you click the link in the chat box to your right to answer a quick survey that will only take 1.5 minutes to complete. And this would really help us gauge and continue to improve on these types of events that we run. So on that note, I'll give you about 30 seconds to click on the link, and you can do so after we end. But on that note, thank you again to all of you, and I wish you a fantastic week ahead. Goodbye, and as always, stay safe.